Hey, everybody. Brady, aka the War Hamster, here again. Joining me today is my good friend, constitutional mentor, Douglas V. Gibbs, Mr. Constitution himself. How we doing, Doug?
I'm doing great. Good to see y'all.
I appreciate you coming on a Sunday. This is a topic we've been talking about, since we've known each other. But there's recent developments that's been happening around the country that really bring this topic to bear. And the topic really is, I'm calling this show "Federalism Rising." And obviously, there's not a guest that probably is more qualified to be my second wheel on this one. So thanks for coming. So let's get right to it. A number of weeks ago, we on Alan Meyer's show for the Republic, he brings certain topics, and I had stumbled across something, a case that came out of Hawaii, of all places, that is one of the more promising developments in terms of federalism, nullification, et cetera, than we've seen in a long time. I got to give a hat tip to Brian McClanahan, because he's the one who brought this to my attention. If you like Doug's content and you like my content on the Constitution, Brian McClanahan on YouTube is a show that you absolutely should watch, and he's one of the shows I rarely miss. He's he's a lot like-minded to our interpretation of the Constitution. So, hat tip to you, Brian, for bringing that up to my attention. I'm going to do a screen share here and just give you the Hawaii story and get your commentary. Okay, this just happened. Looks like about February 8th, the decision came down. Hawaii top court upholds gun laws and criticizes the U.S. Supreme Court. Now, this show and this topic is not about gun laws. They could be talking about any other constitutional issue. So this is not a Second Amendment discussion today. But what had happened is a gentleman named Wilson in Hawaii was carrying in Honolulu against the local and state statutes, and he got charged with that. Hawaii charged him. He challenges it. He appeals, and it gets to the U.S. Second Court of Appeals. And they basically said that, quoting some of the bad parts of the Bruin decision, he basically said that that Hawaii was wrong. Well, Hawaii comes back and says, "Okay, that's great. It's a nice ruling. We're going to ignore it." And his article, and this is from Reuters, says Hawaii Supreme Court says it disagrees with the Supreme Court's Second Amendment rulings. Court upholds laws barring carrying guns in public without a license. Now, I don't want to focus on the gun part about it. What the thing to focus on is that the most liberal state in the union, Supreme Court, voted 5-0 and said to the Supreme Court, "Nice ruling you got there. It'd be a darn shame if we ignored it." What say you?
Well, and here's what it comes down to, because people get caught up on sometimes what the topic is, and right, wrong, or in between. It's going to come down to what does the law say. One thing that, and let me kind of qualify this a little bit with a discussion about the courts itself. Our courts are not supposed to have conservative judges, liberal judges, communist judges, freedom-minded judges. Our judges, their job, the justices at the state court level, at the federal court level, and any other level, their job is simply the law, to apply the law. Whether they like the law, disagree with the law, they think it's constitutional, they think it's unconstitutional, doesn't matter. Their job is the law. See, if you've ever seen this little statuette or statue of justice holding up, it's got the scales and, and what's over the eyes of justice? A blindfold, because justice is blind. What that means is what your opinion is doesn't matter. What does the law say? And this is where Hawaii, even though they ruled in a manner that as ideologically I would disagree with, they got it right when it came to the law and the way the Constitution is established. People sometimes get hung up on, well, gun rights or whatever. Set that aside and let's get to the Constitution. The question is, why was the Constitution written? Why is a federal republic different from other systems in the world? And what really, truly is federalism and the enumeration doctrine? And that's what this is all about. So when it comes to Hawaii, and that my opening statement is they got it right when it comes to the law. I disagree. You should be able to carry a firearm, keep a bear arms. It's a right, but that's up to the people of Hawaii to deal with that with their government.
Yeah, and it's just the opposite. The Bruin case, a lot of the gun rights advocates celebrated the Bruin case in the Supreme Court because they got it right on the gun part, but they actually got the federalism part wrong.
Exactly.
And by what I mean by that is, if you follow the original intent of the Constitution and the enumeration doctrine, the federal courts had absolutely no business telling New York what to do with their own gun laws. That's a New York issue.
Well, an example I like to use when I teach my classes about this is McDonald v. Chicago, which goes back, I think is 2014, 2012, something like that. And what happened was Chicago decided to ban handguns. And it worked its way all the way up to the Supreme Court. And even Clarence Thomas, who I like most of the time, ruled that what Chicago had done was violate the Second Amendment. And therefore, they could not ban handguns. Now, your natural right is to keep and bear arms. So based on our rights, that was a bad move by Chicago. But the Second Amendment, the language shall not be infringed, that applies to the federal government. States are allowed to make some gun laws. It's a local issue. And so when the Supreme Court told Chicago they were no longer allowed to ban handguns and it was unconstitutional, my phone blew up and my email blew up. Everybody's saying, well, gosh, Doug, what a great win for gun rights. And my response was, don't be so sure. Do you really believe that it's constitutional, that it's a good thing, that a federal court is dictating to your local government what it can or can't do regarding your gun rights?
Yeah, and because I don't want this conversation, because we're talking this particular case focused on gun rights, I don't want this to turn into a Second Amendment conversation.
No, I understand that,
but I bring up the
point for some reason.
Yeah, I bring up the point for a reason. If we were to say we were talking about the Fifth Amendment, or the Fourth Amendment, and have the exact same conversation, it applies. So take the gun part out of this conversation. This is about federalism and states' rights.
Sure.
Who has the authority?
When it comes down to what federalism is.
Yeah. So what I want to do now is I want to jump into the actual Hawaii Supreme Court decision and what they said, because there's some really, really nice quotes in there that you just wouldn't expect out of a Hawaii Supreme Court. And if they're thinking like this, the other 49 sure as heck better start following suit. And I'll just stop after each quote and let you get some commentary there. I've got these all bookmarked. The first one, we'll do the first two in order. We talk about the Bruin decision. That's the New York Supreme Court gun law case. Snubs federalism principles. Now, this is a Hawaii Supreme Court saying that. Still, the United States Supreme Court does not strip states of all sovereignty to pass traditional police power laws. Says designed to the people. It should be designated. So that's a powerful statement. You would not expect that to come from, again, a Hawaii judge.
And let's stop there for just a second. Police power, that's the term. So the first question is, where in the Constitution does it give the federal government police powers to police the states, to dictate to the states? It doesn't.
It does not. All right, going down a few more pages, some other juicy quotes. First, he's talking about the Maui Department of the Prosecuting Attorney counters. He says, first, the Second Amendment allows for some restrictions per Heller and Bruin. Interesting. For instance, registration and permitting are constitutional. Second, unlike the Bruin plaintiffs, Wilson illegally possessed the handgun because he never tried to. Okay, that's not important for our conversation. But they said this quiet part out loud. The Second Amendment allows for some restrictions to regulate laws in your state. The Second Amendment doesn't address state gun laws or any other laws in any way, shape, or form. So I thought that was interesting, worth bringing up.
Well, the important part when it comes to the Bill of Rights, and this is where we get into kind of the corporation doctrine a little bit too, or the fact that it was never intended and never should have been put into place, is if you read the preamble to the Bill of Rights. See, most people don't know the Bill of Rights have a preamble. Of course, most people don't know that there's more to the Constitution than the original preamble, first preamble, and the Bill of Rights. They don't know there's more to it. But anyway, there is a preamble to the Bill of Rights. And if you read the preamble to the Bill of Rights, it explains that the purpose of the Bill of Rights, in other words, the first 10 amendments. And as a matter of fact, I'll pull out a pocket constitution here and I'll read it word for word. That way there's no confusion here. Okay.
I was getting ready to pull it up for you, but I'm taking
Yeah.
there.
And so here's what it says. Very first paragraph of the preamble of the Bill of Rights. The conventions of a number of the states, having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers. This is the government being created, the federal government being created by delegates or deputies, some states call them, from their states at this, not just at the convention, but now those delegates are representatives in a Congress, and it's saying there's a problem here. The states are saying we don't like this government. We fear it. We want to make sure that it does not usurp its power. It does not usurp the Constitution, should I say, that it does not overstep the bounds. So in addition to the fact that these powers are not given to the federal government, we want declaratory clauses that says, by the way, thou shalt not. And that's what the Bill of Rights is. If you look at the Bill of Rights, you look at the beginning, end, or middle of some of these amendments. And I love going through these because I think it hammers it home. The first words of the First Amendment is Congress shall make no law. The last words of the Second Amendment are shall not be infringed. First words of the Third Amendment, no soldier shall. The center of the Fourth Amendment shall not be violated. These are not words giving the federal government authority over the rights that are enumerated in these amendments. It's saying hands off, none of your business. Now, that said, someone's got to make some laws regarding these issues. They're local issues. And the way I like to, explain it, and please don't misunderstand me. I had a nice conversation the other day about this. My 7-year-old grandson, Carmine, I don't want him to be able to walk into a gun store on his own without parental guidance, without parental, accompaniment, walk in, buy a gun, buy some ammo, and walk out. He's 7 years old. And then a woman got upset. So you don't think a 7-year-old should be able to shoot a gun? That's not what I said. I learned how to shoot when I was 6. I taught 3 of my grandkids how to shoot. One of them was 9 at the time. That's not what I said. I said I don't want him to, without parental guidance, without parental accompaniment, just walk in and buy a gun and buy ammo. Because he is not at an age where he fully is capable of understanding everything that goes along with that purchase. Maybe he is. Maybe he's not. And it depends on the different state culture too. But somebody's got to make that law, and shall not be infringed. The Second Amendment means shall not be infringed. Or should, we can go through any of these, as Brady pointed out earlier. This is just, it makes such a great example. That's the reason guns work out so well. But the point is, so what's the purpose of the Bill of Rights? What's the purpose of federalism? Because federalism says the federal government only has certain authorities. It's not a national government. This is not a government that can make laws over everything and supersede everything because it's the ultimate ruling elite power. Our federal government was only given certain powers, certain authorities. That's good for the union. Local stuff, that's up to the states. And so this is where now, because the states sent their delegates, they sent their deputies to the Constitutional Convention, the states say, we're the parents, we created this creature, and we have the right to nullify if it is operating in a manner that's outside the contract we made as parties to that contract to create it in the first place. And that's where Hawaii is getting it right. Hawaii is saying, hey, we believe in federalism, and we have our own local culture, our own local way of going about this, and it's none of the federal government's business, and they're not given the authority to have any business involved in this. It's up to us. And that's basically the message.
Yeah, and a more simple way of putting this is agency versus principle. These 13 sovereign states were principals to a contract.
Mm-hmm.
They created an agency, which is the federal government. In no way, shape, or form does the agent, can they act outside of the contract, nor do they have power over the principals, who are the sovereign states. They were not giving up their sovereignty. They were delegating authorities to a central authority, to central government, to have a more cohesive union.
Mm-hmm.
And no, they were not, New York was not telling New Jersey what they could or couldn't do. Had they thought that this was the case, it never would have been ratified. That's what the entire purpose of the Federalist, Anti-Federalist papers. That was what they were talking about at the ratifying conventions of Virginia and New York. This is what Madison said in his notes. This was their fear. We are not giving up our sovereignty, because Pennsylvania was its own nation. New York was its own nation. Virginia was its own nation. We bound together as a union for common defense and for interstate trade. And that's what the general government, which is the word they used, was created for, was to help make that go more smoothly and to coordinate the mutual defense and international affairs. And that was it.
No, and you had a union of states who saw themselves as individual entities under the Articles of Confederation, but they're realizing we are not only unable to resolve our conflicts among each other, so we need a mediator for disputes between the states or disputes within the states. A mediator, in other words, a neutral party to come in and negotiate something that is agreeable for both sides, not a ruling government that dictates, but also they are in a world full of empires. They've got to deal with the rest of the world. They've got trading partners on the other side of the ocean. And, could you imagine today if we were still under the Articles of Confederation and there's a trade agreement? So we're going to send 50 negotiators. The federal government was needed to be that single body in the name of for the union, so that it could handle those issues that a country's officials would handle. But when it comes within the states, domestic, still up to the states, because they're each individual sovereign entities, autonomous, if you want to use that word.
Yeah, it was a federation, a federal republic.
Mm-hmm.
All right, I want to jump into some more of this decision, because this next part I'm going to be reading for a bit. There's some really juicy language. This is going to be red meat for you.
Red meat for me. I'm excited. Go for it.
All right, here it comes. This court has yet to explain how we interpret matching state and federal constitutional provisions when both are in play. Do we look at the state constitution first? The federal constitution first? Both? If we interpret our constitution to provide more protection, do we even take up the federal constitution at all? We believe that the proper sequence to consider matching constitutional texts is to interpret the Hawaii Constitution before its federal counterpart. Only if the Hawaii Constitution does not reach the minimum protection provided by a parallel federal constitutional right should this court construe the federal analog. A couple things there. What I don't like is they talked about a constitutional right. There is no such thing.
Well, they're saying it as if the federal government sets a standard, and as long as we meet that minimum, well, no. If it comes down to while you were reading that, my first words in my head were, well, it depends on what it is. It comes down to authorities.
Yeah. Some things are delegated to the federal government. Some things are left to the states as per the 10th Amendment. All right, continuing on this. Thus, we interpret the Hawaii Constitution first. I love that. Giving your state constitution priority.
Well, if it's a domestic issue, absolutely. Correct.
Yep. And may not get to the United States Constitution. See State versus Kono. If we address the state constitutional claim first and decide it in favor of the defendant, there is no reason to address the federal constitutional claim. This is a previous case. For purposes of that case, the defendant is entitled to prevail under the state constitution, and it simply does not matter which way the claim would have been decided under the federal constitution. Continuing under State versus Moylet, if no state law, including the state constitution, resolves the issues, courts then should turn for assistance to the Constitution of the United States. How's that for turning the supremacy clause, in quotes, air quotes, up on its head?
Oh, absolutely. Yeah. Once again, at that very end of that one, also, it really comes down to authorities. If the federal government doesn't have authority, you don't go to them for resolution. It's done. But if there is a federal authority, then you go to the federal government for resolution. It really depends on where the authorities lie. And, if the federal, and once again, just for the audience, if the federal government is not given the power in the Constitution, and that includes amendments, in other words, it's not listed in the Constitution, they don't have the power. And I don't care if we want to interpret or if we want to imply, we can do that all day long. comes down to whether or not the power is expressly enumerated in the Constitution. Now, that said, just because something is not constitutionally enumerated towards the federal government doesn't mean they ought not to do something. There's a lot of things they ought to do, but let's get it enumerated in the first place.
Yeah, you can make arguments for things like judicial review, and they did that on the floor in Philadelphia. It was voted on, discussed, and shot down. You can make the argument, but if you want to impose federal judicial review or any other type of federal mission creep, go ahead and go through the process of getting an amendment passed.
Ask the states for permission. It requires their ratification. And the example I like to use is aviation. Should the federal government have authority over aviation? Absolutely. But they never asked for it. So actually, technically, they don't have the authority. So, the aviation laws at the federal level, federal aviation agency is unconstitutional. Does that mean I think then they shouldn't be doing it? Not necessarily. Ask for the permission. That's what it's all about. Because remember, getting back to what you were talking about earlier, the parties versus the agency. The parties of the contract, they're the ones that created the agency. It's like a parent creating a child. The child, the agency, before it accrues more approved powers, it has to get them ratified, approved by those who made it, those who are the parties to the contract that created the agency in the first place. In a contract, if you, the listener, and Brady and I were three parties in a contract, and I said, hey, we ought to be doing this, so let's just start doing it. And everybody says, wait a second. Our board, the three of us, have to sit down and discuss it and vote on it. Then, if we approve it, the amendment can be added to the contract. Until then, we can't do it. The Constitution is no different.
Yeah, I would agree. The funny thing about your analogy of the parent and the child is just like the government, the child eventually grows up and takes all the power for itself. And that's the sad part about what actually happens.
More often than not, acts like an idiot until they figure out that they're idiots.
All right, I'm going to just read a little bit more about that, and we'll go to the next case. But like I said, this is red meat. And can you imagine if you had 49 other states were having these conversations about which constitution? The federal government they'd be buried. They'd be completely stymied with.
Hey, 49 other states, give me a call.
Not at the same time. Okay, one more screen.
At the same time, yeah. Go ahead.
All right, interpreting the Hawaii Constitution is this court's number one responsibility. That's reasonable. So we reason independently, untethered from the Supreme Court's analysis of the U.S. Constitution. Hawaii's people are entitled to an independent interpretation of the state constitutional guarantees. The court called a case called State versus Ball, and I think I have that right here. Oops, hang on, let me find it. I've got it. There's some really fun stuff in there. Bear with me. There it is. I got my tabs out of order. My apologies. So State versus Ball was a case decided in 1983. And it's New Hampshire of all places. But here's some of the things that came out of that ruling. New Hampshire Constitution. Generally, when a defendant has invoked the protections of the New Hampshire Constitution, the Supreme Court will first address those claims. New Hampshire Constitution. Construction. Although the Supreme Court has often treated federal and New Hampshire constitutional protections similarly, the citizens of the state are entitled to an independent interpretation of state constitutional guarantees. Talking about judicial power and duties. Generally, when state constitutional issues have been raised, the Supreme Court has a responsibility to make an independent determination of the protections afforded in the New Hampshire Constitution. There's a pattern emerging here that time after time you need to defer to the state constitution first. Again,
and my frustration there, let me add this real quick. My frustration there is that they are both looking at it as a hierarchy system. It goes to the state first, and then if we don't resolve it, then the federal government gets involved. No, they go to the state constitution first if it's a state issue, and the federal government never gets say.
Yeah, in Article 3, they specifically left out the federal judiciaries having any authority over intrastate affairs. It's only when it crosses state borders where the federal judiciary has any authority whatsoever.
And even that's a false idea, because if you read carefully the Constitution and you read the notes regarding it, crossing state lines is not what makes it a federal issue. Crossing state lines and there being a dispute makes it a federal issue. If there's no dispute, in cross state lines all day, no problem. There's no reason for the federal government to get involved. The federal government's role there is domestic tranquility. In other words, to act as a mediator when there's a dispute. No dispute, none of their business. Ultimately, that was what was originally intended. Anyway, continue, please.
Now, of course, the nationalists, calling themselves Federalists, changed that in 1791,
Right,
with the Judiciary Act of 1791. And I've made this argument to you before, that you can make the argument that the Judiciary Act of 1791, which gave the federal courts authority over just in state affairs.
John Marshall had 2 or 3 other cases where he hammered it down too.
Well, it absolutely is unconstitutional. You can make the argument that's necessary, but it required an amendment to the Constitution.
Right, exactly.
This passed literally 2 years after the Constitution was ratified, or 4 years, I'm sorry. 2 years. Get my dates right. So I want to switch over to something that's coming out of Utah. And this is a state law that's just been passed.
Okay.
And I've got that right here. I'm going to go to the 10th Amendment Center, who's been talking about this stuff for 15 or 20 years.
I like those guys.
Yeah, they are great. What's his name? Mike Bolton, I believe is his name, the main guy there. Anyways, they do a fantastic job, especially on this topic, because that's why they call themselves the 10th Amendment Center. This is in their wheelhouse. So, Utah bill would create a process to end state enforcement of some federal acts. This is published in January 8th. That bill has been signed into law. So Utah has done the job. I'll just read it to you. A bill filed in the Utah Senate would create a process to end enforcement of some federal actions in the state and set the stage to nullify them in practice and effect. Senator Scott Sandel filed Senate Bill 57, SB 57. Under the proposed law, the Utah Legislature would have the authority to pass a concurrent resolution prohibiting a state or local government officer from enforcing or assisting in the enforcement of a federal directive within the state if the legislature determines the federal directive violates the principles of state sovereignty.
Nice.
Can we just read that for an hour straight?
That's like nullification in action.
But it's important to understand what they're actually saying here. They don't have the power to, say no. They're not saying that the federal law is null and void. What they're saying is, okay, fine, go ahead and enforce it. No state officer, we will not allow a state of Utah officer to enforce a law that our legislature is deemed unconstitutional. We will not permit our people to break a law that we believe.
Now, that said, the federal officers are not supposed to operate within a state without the state's permission. So
it gets interesting because it turns out a vast majority of federal statutes are enforced by state personnel.
Right.
The federal government doesn't have anywhere near the manpower to enforce everything that they would like to do. So they're absolutely dependent on these states. And
it's sort of like getting the businesses during a certain period not too long ago to enforce the mandates of the government. Same type of thing.
Yeah, and of course, all of our lifetimes, the states have basically done whatever the federal government has told them to do. Basically, a lot of it has to do because they need that federal grant money. Yeah,
well, every once in a while, a state pokes back. Arizona did it a couple times with the 55 speed limit, with the daylight savings time, and with Martin Luther King Jr. birthday. And so Arizona was robbed, even though they shouldn't have had it in the first place, federal funds for their highways, which were unconstitutional in the first place. But, because that's how the federal government works. Well, we can't force you to do it, but we'll take away money from you that we're not supposed to give it to you anyway for something that's your responsibility anyway. But so we have seen states poke back before, Arizona being famous for it, but it's not often. It's very rare. And for the most part, gets back to what I was saying earlier. The problem is our critters in legislative positions or in officer positions, executive positions, or whatnot in our states believe that there's a hierarchy, that there's a national government, and the state is somewhere further down on along the food chain. And that's just not right. We do, the federal government is not the top predator in the food chain. It comes down to where the authorities lie, and I can't count how many times I feel like I've got to hammer that down with people. It depends on where the authorities lie.
Yeah, and it says it all throughout the Constitution and other founding documents. Who are the sovereign? The states created the Constitution, and I know you like to cite this one quite a bit, but it's Article. I think an article. So, how do we ratify the Constitution? The ratification of the conventions of 9 states shall be sufficient to the establishment of this Constitution. Who's doing the ratifying?
7.
Yeah. Done in convention by the unanimous consent of the states present. Skip over. Where's the part that says 18.7? I'm blue. I lost it. Witness thereof, we have hereunto subscribed by names. What they're basically saying is it's the states that
Well, they're ratifying it. It requires an agreement of the parties to the contract. If it wasn't a contract, there would be no ratification.
Yeah, and that shows where the sovereignty lies. And I think that's the concept of sovereignty is a really big deal, and it's gonna be something that's going to be in the lexicon for quite a bit going forward, as you see the push towards globalism continue to try to take away nation states' rights. I've talked about global treaties that have no enforceability except for blackmail by the IMF and the World Bank. But that's a different topic for another day. Let me jump back into this article by the 10th Amendment Center because they go into some of the founding arguments that back up.
Very good. Okay.
Okay, SB 57 defines federal directive as a statute passed by Congress, an executive order by the President of the United States, or a rule or regulation adopted by a federal agency. And we've talked about all 3 of those concepts. I don't want to go down those holes because I know we could have some fun there. A federal directive would violate the principles of state sovereignty if the federal directive restricts or infringes upon a power or a right reserved to the state by the 10th Amendment to the United States Constitution, or the state's rights or interests to provide for the health, safety, and welfare and promote the prosperity of its state's inhabitants, as determined by the state legislature.
And, they used 10th Amendment language, reserved to the states. And what does reserve to the states mean? Reserved or retained means they had that authority in the first place. Prior to the Constitution, the states had all authorities on all issues. Now, under the Declaration, under the Articles, they had all authority over all issues. They gave the federal government some of their powers, but they retained or reserved the rest to themselves.
Yeah, and I like to use the pie analogy. If you look at the pie, all of the authorities that any sovereign state could have is a pie. They carved out a couple small slices and gave it to the federal government. And, that was what was ratified. Unfortunately, over the last 240 years, the federal government has carved out more and more of the pie. So now it's almost the entire thing. States have a little bit left. So the bottom line is we need to get our pie back.
So, or you could say this, one small slice does not make a whole pie. But they seem to think it does.
Yeah. And they worked really hard to do that over a long period of years. And, sometime in the mid 1800s, it just became it's accepted as fact that we were a national government. Okay, going back to the screen share. I should transition that more quickly. I apologize. Based on James Madison's advice for states and individuals in Federalist 46, and Federalist 46 is a beauty, talking about state sovereignty, a refusal to cooperate with the officers of the Union provides an extremely effective method to render federal laws effectively unenforceable because most enforcement actions rely on help, support, and leadership from the states.
All right, stop right there. What does it say in Article 1, Section 8 when it comes to executing the laws of the United States? Because, see, notice what he said there. To enforce these laws, to execute these laws, it takes what? The states. So we go to Article 1, Section 8. of the United States Constitution. I'm turning there now to make sure I read it properly. And it says that the Congress shall have the power to provide for calling forth the militia to execute the laws of the Union, the militia belonging to the state. In other words, the federal laws that would be executed within the states would be few and well defined. There'd be very few of them. And if there is a law within a state that needs to be executed, the executing entity is the local state militia. In other words, the state officers or state personnel. So what does that say? And I know I'm going off on a tangent here, but it's important here. What does that say about the creation of, I don't know, the FDA, the ATF, the IRS, the FBI, the CIA? Well, CIA, I guess, is okay because it's foreign stuff.
Oh,
but the internal stuff is what I'm talking about. Internal law enforcement by the federal government.
CIA is supposed to be foreign only.
Well, yeah.
We don't need to get into that today.
Yeah, but my point is, if it is the job of the militia to execute the laws of the Union, and in Federalist Paper number 46, Madison's saying it's going to be state personnel that's going to execute the laws of the Union that are domestically applicable because there is an enumerated power for it. Where are all these policing agencies coming from? There's no authority for these policing agencies. The federal government's got no business walking into a state and trying to dictate their powers upon that state. If it is an authorized thing, then the states will carry it out. If it is not, the states won't. That's the way it was originally intended.
Okay, this legislation could effectively enforce any federal law and enforcement of any federal laws deemed to violate the Constitution. Fox News senior judicial analyst Judge Andrew Napolitano agreed this type of approach would be extremely effective. In a televised discussion on federal gun laws, he noted a single state refusing to cooperate with enforcement would make federal gun laws nearly impossible to enforce. The federal government relies heavily on state cooperation to implement. We've already said all this. As noted,
state don't cooperate, it don't happen. That's how nullification takes place.
Yep. As noted by the National Governors Association during the partial government shutdown of 2013, states are partners with the federal government on most federal programs. Let's get into the legal basis for this.
And here, let me help you handcuff me.
Sorry, there you go.
Go ahead.
The provisions prohibiting the state from enforcing or implementing certain federal acts rest on a well-established legal principle known as the Anti-Commandeering Doctrine. Simply put, the federal government cannot force states to help implement or enforce any federal act or program, whether constitutional or not. The Anti-Commandeering Doctrine is based primarily on 5 Supreme Court cases dating back to 1842. Prince versus the U.S. serves as the cornerstone. We can get into that in a second. I want to go into what the
that's very important stuff because it's basically saying the federal government can't force the states to implement this stuff.
Yep.
But they're doing it voluntarily, and that means they can stop doing it voluntarily. Continue, please.
I'm going to go into the Anti-Commandeering Doctrine a little bit more, also from the 10th Amendment Center. They wrote about this in 2021. The Anti-Commandeering Doctrine provides a powerful tool to undermine overreaching unconstitutional federal power. So what is this doctrine? What is it based on? And how can it be used as an effective tool for liberty? Most people, let's just go down to the good part. In his blueprint for resisting federal power, Madison offered a number of actions. Most significantly, he suggested a refusal to cooperate with the officers of the Union. And he's going to quote from the 46th Amendment, which we already talked about. Anti-commandeering is a long-standing Supreme Court doctrine. In a nutshell, the Anti-Commandeering Doctrine prohibits the federal government from commandeering state personnel or resources for federal purposes. In effect, the federal government is constitutionally prohibited from requiring states to use their personnel or resources to enforce federal laws or implement federal programs. State and local governments cannot directly block federal agents from enforcing federal laws or implementing federal programs, but they do not have to cooperate with the feds in any way. For instance, a local sheriff cannot block ATF agents from enforcing a federal gun law. Now, let's not get into that. But the ATF cannot force the sheriff's office to participate in the enforcement effort.
Well, but if they can't operate in the county in the first place without the sheriff's permission, they can't carry it out either.
So this goes on to talk about the other Supreme Court cases, and a couple of them are worth mentioning. Let me see if I have a couple of them specifically dug up, or we'll just go through the article. Yeah, let's just go through these ones because all these Supreme Court cases, they matter, and we'll tie it up and say, how is this, creating a movement towards federalism? Well, again, I wanted to title this video "Federalism Rising," and we'll conclude with that in a second here. I just wanted to go through the court cases. First one is Prigg versus Pennsylvania, where Joseph Story, of all people, agreed with. For those who don't know, Joseph Story is a Supreme Court justice and also I believe, was Harvard professor who wrote a lot of terrible nationalistic.
He's got his commentaries on the Constitution that, while some of it hits the mark, most of it is Hamiltonian garbage. But anyway, go ahead.
Joseph Story held that the federal government could not force states to implement or carry out the Fugitive Slave Act of 1793. He said it was a federal law and the federal government ultimately had to enforce it. The next one, I don't think we need to go into the principle of that, do we?
No.
Okay. The next one is in New York versus United States. The court held that the regulations of the Low-Level Radioactive Waste Policy Amendment Act of 1985 were coercive and violated the sovereignty of New York, holding that because the act's take title provision offers the states a choice between the two unconstitutionally coercive alternatives, either accepting ownership of waste or regulating according to Congress's instructions, the provision lies outside Congress's enumerated powers and is inconsistent with the 10th Amendment. This was a 6-3 decision, and even Sandra Day O'Connor was on their side of federalism that time.
It's like, it basically, for the layman there, the federal government was dictating either you hang yourself or you shoot yourself, your decision.
Pretty much. And, it's funny, you have these justices who've quite often, you would say, fallen on the bigger government side of things, are taking our side on these cases.
Yeah.
This is really not.
Well, and it's funny because I believe that a lot of these judges who lean leftward don't like the idea of state sovereignty and localism. They recognize it is a cornerstone of what our system is, so they know not to traipse too far on top of it. They're very careful. They don't want to alert you that they're trying to take away the sovereignty that quickly, that much. And some of them actually, I think, are thinking about it. I think they do use a little critical thinking. But I think most of them, it's the boiling frog. They don't want to turn up the heat too much.
Well, and here's what a couple of her comments on this will show you that she's not 100% where we would like her to be.
Okay.
As an initial matter, Congress may not simply commandeer the legislative processes of the states by directly compelling them to enact and enforce a federal regulatory program. That's fine. That I agree with. She expounds on it later. While Congress has substantial powers to govern the nation directly, we'll address that. Including in areas of intimate concern to the states, the Constitution has never been understood to confer upon Congress the ability to require the states to govern according to Congress's instructions. Take it away, Doug.
That is essentially right. But, it's funny because she kind of reminded me in this with a senatorial candidate here in California who says, I'm very, very conservative. And that's why we need to use the power of the federal government to get California straightened out. No, the power of the federal government has no business in the state. That's between the citizens of the state and the state. And that's what it kind of sounded like to me from that point of view. And once again, it goes back to, are the powers enumerated? Does the federal government have that authority? And once again, she's speaking from this, and this is, and I know I'm repeating myself, but it's important. She's speaking from this point of view of there's a hierarchy. The states are allowed to do so much, and we can't force them to, but if really push comes to shove, we're in control. No, it depends on where the authority lies. If there's no authority, federal government's got no say whatsoever.
Concur. Next case we have is Prince versus United States. This serves as the linchpin for the Anti-Commandeering Doctrine. At issue was a provision of the Brady gun bill that required county law enforcement officers to administer part of the background check program. Sheriffs Jay Prinz and Richard Mack, your friend, sued, arguing these provisions unconstitutionally forced them to administer a federal program. Judge Antonin Scalia agreed. Writing in the majority opinion, it is apparent that the Brady Act purports to direct state law enforcement officers to participate, albeit only temporarily, in the administration of a federally enacted regulatory scheme. Now, let's skip over the fact that all federal gun laws are always unconstitutional. Let's skip over the fact that our friend Richard Mack was part of this victorious case. This is Scalia, who is probably my favorite living justice. And we just passed the anniversary a couple of days ago of his passing away. So we had to say a prayer for Justice Scalia. This is the same concept we're talking about. Citing the New York case above, the court majority declared this provision of the Brady gun bill unconstitutional, expanding the reach of the Anti-Commandeering Doctrine. If they're unable to enforce their federal laws, it basically is null and void. And that's the beauty. That is the absolute beauty,
right,
of asserting state sovereignty. Do we need to read the decision? Probably it's going to be self-explanatory. Next case we have is Independent Business versus Sebelius. The court held that the federal government cannot compel states to expand Medicaid by threatening to withhold funding for Medicaid programs already in place.
And that goes back to what I was talking about with Arizona before, that the federal government has this tendency. We know we're not allowed to force you to do something. It's voluntary. But if you don't do it, we're going to withhold money. And the Sebelius case, I'm familiar with it, basically said you can't do that. I wish that same idea, that same concept would be expanded to a lot of the other things that they do this with. We see it often. And usually federal highway funds are usually the culprit. But it's like, and state governments do this to cities often too. I remember when I was very involved with Murrieta City Council, and there was something coming down from Sacramento here in California that when your general plan will include, and the city says, "Well, we don't want to do that. That's not something we want to do." It was low income housing and how we're going to place housing and so on and so forth. And Marietta said, "We're not going to do it." And the state said, "Fine, then we won't give you your funding for expansion of certain areas in certain zones."
Yeah, and that's
same stuff.
Yeah, that's exactly how they've implemented these Agenda 21 provisions inside of almost every municipality's government. I don't care where you live in the country. If you look at your city or your municipality's code, you're going to find Agenda 21 language in there that you had no idea that they'd ever passed, because they'd never debated it. They hid it in the small fine print. And
Agenda 21 is not a treaty and it's not the law. Well, then how is it it's being developed, that's being followed, and development is following? Well, because your development funding for a city is dependent upon you following those recommendations.
Last case we have on this is Murphy versus the NCAA. The court held that Congress can't take any action that dictates what a state legislature may or may not do, even when the state action conflicts with federal law. Now, this one's pretty powerful.
Well, it comes down once again to authority. So go ahead.
Samuel Alito wrote, "A more direct affront to state sovereignty is not easy to imagine." He continued, "The anti-commandeering doctrine may sound arcane, but it's simply the expression of a fundamental structural decision incorporated into the Constitution, i.e., the decision to withhold from Congress the power to issue orders directly to the states. Conspicuously absent from the list of powers given to Congress is the power to issue direct orders to the governments of the states. The Anti-Commandeering Doctrine simply represents the recognition of this limit on congressional authority. That's could not have ended on a better note.
Mm-hmm. And I miss Scalia. Alito and Clarence Thomas are my two favorites currently. The Alito, Scalise, Clarence Thomas trio was fantastic when it existed. But here's the thing, ultimately, while our courts are important and their application of the law and the application of the Constitution is important, and these judicial opinions are important, it is not the be-all, end-all. Just because a Supreme Court justice wrote something does not mean that it is written in stone constitutionally, and that's just the way it is. Tough. And this is where I really appreciate Thomas, because in the 2019 Gamble versus the United States case, in his judicial opinion, Clarence Thomas wrote that if a precedent or a judicial opinion or a ruling is egregiously unconstitutional, it must be overturned. In other words, we make mistakes. We can mess it up. We can give you the wrong opinion or the wrong ruling. And if it is against the Constitution, it's against the law, it needs to be reversed. Because once again, and I said this at the very beginning, their job is not interpretation. Their job is not to imply or find implied powers or implied law. Their job is to follow the law and apply the law as it is written.
Yeah, and if they do anything else, they're assuming the legislative powers.
Mm-hmm.
And that goes directly opposed to the entire separation of powers edict. Yeah, and we've got several cases making their way through the Supreme Court that have already been heard. We've talked about that a little bit, but you're going to find out that these federal agencies who are acting as rule makers, application of the law, in terms of enforcement of the law, and then they adjudicate the law. They're taking on all three of the powers of the government through a federal agency that is not even conconstitutionally allowed to exist in the first place.
Right.
That is being challenged.
And we've seen it a few times. The EPA, matter of fact, just a few months ago, slapped for exactly that.
I was going to bring that case up on our show last week, but we just didn't get around to it. I had it all queued up. That's very important. And the same thing's going on with the IRS. And there's several of these agencies, and their right to exist may be called into question, which would be good. All of these regulatory bodies, some regulation is required. When you're looking at a very powerful economy, the question is, whose role is it to do that? Is it the federal government? And if so, pass an amendment to give yourself that authority. If not, it reverts back to the states.
Yeah, it goes back to what I said earlier about aviation. Same thing. So if the power needs to be there, get permission.
Yeah,
go through the process.
In the case of aviation, it makes more sense to have it centralized than to have 50 different state aviation agencies.
Absolutely.
Yeah, it does make.
But they don't have permission.
No.
Go through the process. That's all I ask.
So bringing this home, these are two really good examples of the states realizing they actually have the sovereignty that they never should have given up. And we should be pushing these things out as an example to our states wherever we live and say, why aren't you doing this? And let's elect people that are willing to do it, to stand up and say, hey, my state has sovereignty and we don't need to be pushed around. And there's really not a darn thing the federal government can do about it. So the reason I wanted to call this recording Federalism Rising is because there's change in the air. The federal government's grown. We've now got the largest, most powerful government in the history of mankind. That's the opposite of what the founders ever intended. And if we ever want to go back to being in a federal republic, it's got to start local and at the state level. And we're giving examples of how that can actually be done without having to even have the conversation that people want to go, civil war, because that's an unthinkable conversation. So, but there are many legal means to push back against the Leviathan known as our federal government. Any final thoughts, Doug?
Final thoughts is that, and I've been wanting to do a video on what is federalism, just that, and I'll be doing that. So, those of you who wish to follow me and keep an eye out for things like that, DouglasVGibbs.com and politicalpistachio.com. But as for our discussion, I think it was on target. I think we covered a lot of things a lot of people don't know. And so I appreciate the fact that you, the listener, viewer, has tuned in, because wanting to learn this stuff and is half the battle. Being informed is important. You can't fight for liberty if you don't understand what it is and why you have it.
Very good, Doug. And I think you guys can all expect to see a lot more videos like this from Doug and I. The one we did a couple weeks, about a month ago, got a really good reaction from my followers on Rumble. And looking forward to doing a lot more shows like this. You can find me. If you're watching this show, you probably know where my Rumble channel is, war_hamster. You can get me on Twitter at war_hamster1776, and also on Truth Social at war_hamster. With that, Mr. Gibbs, I think we will end this show, and thank you very much for your time.
Thank you.